Hi guys, in this video I will talk to you about Consumer Protection Act 1987. A claim as a result of faulty goods can be brought in two ways. First is negligence, and then Consumer Protection Act 1987. So if someone wants to bring a claim as a result of faulty goods for personal injuries or death, then they can do so in negligence, under the principle of Donoghue versus Stevenson. Now, in Donoghue versus Stevenson, a claimant, Miss Donoghue, and her friend went to a cafe. Her friend bought her a ginger beer, and when Miss Donoghue drank the ginger beer and poured the rest out, the ginger beer contained a decomposing snail. So, as a result, she became ill. She tried to sue in the law of contract, but she could not because of the privity rule which existed between her friend and the seller of the drink. Therefore, she brought a claim under the tort of negligence. So the law here is that manufacturers owe duty of care to their ultimate consumers. Here, Miss Donoghue, or claimant in negligence, would have to prove fault. So Miss Donoghue, if she brought the claim under the Consumer Protection Act rather than negligence, she would have been able to sue the seller of the drink, as well as the manufacturer of or any other producer of the drink. Okay, so the Consumer Protection Act. This act allows a claim for personal injuries arising from faulty goods. Now, the Part 1 of the act allows a claimant to sue the producer of a product, and the claimant does not have to prove fault. So the liability under this act is strict. So the act finds producer of a product liable, and there are various producers under this act which are found in section 1 and 2 of the act. So a producer can be those extracting raw materials, manufacturers, own branders, for example Tesco Finest or Tesco Value, those importing goods in the EU, and processors of the goods. Section 2 of the subsection 1 sets down the liability for damages caused by a defective product. Under the Act, a product means any goods or electricity. So own branders like Tesco, Tesco's own brand, Tesco Finest, they will also be regarded as a producer under Section 2 of the subsection 1. So Section 3 of the Act states that a defect on a product is where the safety of a product is not what a person is entitled to expect. Now, there are factors that are not included within the Act, so they are instructions or warnings on the product, the method used to market the product, or what's expected to be done with the product. Section 5 of the subsection 1 allows a claim for death or personal injuries caused by the product. Section 5 of the subsection 2 does not allow a claim for damage to the product itself. So if there is a fault or damage to the product that a consumer purchased from a manufacturer or a seller, they cannot claim for the damage to the product. They can claim for personal injuries or death under Section 5 of the subsection 1. Now, Section 5 of the subsection 4 states that a claim can only be made for damage worth £275 or more. So a claim for death or personal injuries should only be claimed within 3 years period. As well as protection for claimants, there are many defences available for defendants under the Consumer Protection Act. So we will look at a couple of them here. The liability under the Act is strict, like I mentioned earlier, so the claimant does not have to prove fault. They don't have to prove that the manufacturer is negligent. Liability under the Act cannot be limited or excluded by any term or notice. This is found in Section 7 of the Act. I'm not sure if you can see it. Section 7 of the Act. Now, contributory negligence can reduce the damages the claimant can recover. Now, this is found in Law Reform Contributory Negligence Act 1945. Even though the Act is strict, there are many defences available to the defendants. So it may seem as if though the Act is so strict in liability, but there are various defences available to the defendants. So if the defect was caused by the compliance with legislation, or this could be such as the Act of Parliament or EU legislation, then that could be possible defense that the defendant can use when a claimant brings a claim under the Consumer Protection Act 1987. So if a product was not supplied in the course of a business, then that's a defense that the defendant can bring within the Act. And also, if the defect did not exist when the product was on the market, then the claimant will not be able to claim. Thank you for watching my video, and I hope you picked up some information from this.